As lawyers, we tend over a period of time to read judgments only when the matter requires us to do so. And therefore, it's a matter of fact that academic pursuit over a period of time takes backseat over professional commitments. It's only when one is required to give such a lecture at such a seminar, one is required to get into the niceties of, as Dharan has rightly said, a very long but a very, very interesting judgment. But for probably this commitment, I would not have gone through this judgment as closely as I have, at least in such a short span. I must thank CTC for that. Once in a while, you come across judgment which is path-breaking, which in a way opens new vistas for the purpose of arguments, lays down new rules of the game. It shows as to how a judicial mind can take up the challenge of adjudicating an issue, and when the court had or court would have had an alternative to decide the matter in an easy manner or approaching the matter from a complex, more challenging and more fascinating angle, how and why the court prefers the second option rather than the first one. The judgment also comes as a very fresh breeze, in as much as of late, all SSCs have been getting almost every judgment against the SSC. And therefore, a feeling, so to say, was being gathered that now we are not going to get justice from the high courts or higher courts. This judgment, as we will go along, very clearly points out what should be the law and how these kinds of problems should be approached by the courts. We will also see, as we go along, unusual approach adopted by the court in answering the issues which were faced by it, and how, though it might have been far more easier for the court to take a view against the people, citizens, people, it, and in my view rightly, chose a path which substantially gives relief to all people who are facing problems because of the provisions of the Benami Act. The talk is likely to be like in this manner. I would be speaking for about, as Parag Bhai has indicated to me, between 45 to 50 minutes, maybe plus minus 5 minutes. And then we might have a question answer session. Now with this, let's see how the whole case unfolded. We all are aware of the Benami Act, 1988 Act, 2016 amendments, and the issues that arose out of 2016 amendments. Let's see how the court has examined the issue and what is the finding given by the court. I would now start a PPT and then go step by step in relation to the issues decided by the court from time to time. Now, insofar as historical background is concerned, we always have looked at the issue of Benami as something which is contrary to law. Benami as something which is not presenting the facts from clear perspective. The word Benami is also derived from, as the Supreme Court itself says, the word farzi, which probably means, or which is probably likely to carry a meaning that this is all what is illegal. But is this the correct impression that we have? The Supreme Court was dealing with the 2016 amendment under the Benami Act, but while discussing this issue, it has traced the issue historically to find out as to what does the Benami law in fact result into, what was the position of Benami transactions prior to 1988 Act and post 1988 Act. Now, traditionally, Benami is when a person acquires property, but then he does not pay for it, somebody else pays for it. The other person is the real owner. I am the Benamidar. But there is also another category of a Benami transaction where I transfer property to B. A transfers property to B without effectively transferring the beneficial ownership or right, title and interest in the property so as to enable B to enjoy the property. The transfer is only on paper. So Benami transaction could be bipartite, A transferring property to B without intending to transfer ownership and beneficial interest, or tripartite, where A transfers property to B but is paid for by C. C wants to enjoy the property. B is merely a name lender, a Benamidar. Now, this distinction of a bipartite and tripartite Benami situations has a significant bearing to the discussion that we would have today. So I am starting at the outset with this particular Benami position. But the point at issue is Benami transaction something which the law never recognized? Supreme Court traces 3 judgments, and the first judgment is of Privy Council, AR 15 Privy Council, where the Privy Council expressly held, and please mark what Privy Council says, that the Benami transactions are quite common amongst Hindus and Muslims, and they are very much in use in India, and they are not objectionable in nature. Way back, more than 100 years back, Privy Council had recognized Benami transactions and had expressly held there is nothing objectionable in it. Why do I refer to this? I refer to this because if it was not an objectionable transaction to begin with, unless you make tainted transaction by a legislation, they will remain untainted transaction. As we move along, we will see the distinction and how the Supreme Court has drawn about some kind of a design to go from one point to another. So to begin with, 15 Privy Council says Benami transactions per se are not illegal. In fact, they are not objectionable at all. This judgment of a Privy Council was then quoted with approval by Federal Court in AIR 42, a Federal Court, where the Federal Court has taken a view there is nothing inherently wrong in a Benami transaction, and this accords with legitimate scope, ideas, and habits of the people. Federal Court undoubtedly drew a caveat that so long as the transactions are not entered into for a fraudulent or illegal purposes, these transactions are to be permitted. Effectively, therefore, the Benami transactions prior to enactment of the Benami Act of 1988 were not objectionable. AR 80 Supreme Court also, in a way, reiterates that particular principle. Now, the first inroad into the legality of Benami transaction was made by amendment of the Income Tax Act. As usual, the Income Tax Act is being utilized for a variety of purposes other than taxing income. Section 281 Capital A was inserted by the Amendment Act of 1972, whereby not that Benami transaction was held to be invalid. What was prescribed was a person cannot file a suit for recovery of a property which is held by someone as his Benami against Benami unless in his tax records he has already disclosed the property to be his. So if Mr. A is holding property as Benami for B, B is prohibited from filing a suit against A for recovery of the property under section 281A of the Act unless it is found that real owner has in fact shown the property as his property under in his tax records. In other words, the beneficial ownership of the real owner would get snapped if Benami claims ownership of the property for all purposes and the real owner would not be permitted to claim back the property. This again is of 1972 when the Benami Act was nowhere on the horizon. In the year 1973, there is a 57th Law Commission's report. The Law Commission was called upon to decide or suggest to the government how do we deal with the issue of Benami. Now, please mark, Law Commission in his report expressly records that Benami transactions are legal, except in certain specified situations like if they are being used for a fraudulent purposes or for illegal purposes. The Commission wanted to suggest to the government to come up with a piece of legislation to regulate the Benami transactions and to ensure that Benamidars become the owners of the property and the real owner who is financed the transaction does not claim ownership of the property back from the Benamidar. The Law Commission at that stage came up with two broad suggestions. The first suggestion was treat these transactions as illegal, provide that anyone who enters into this transaction is committing an offense, try it in a criminal court, give the defense of mens rea as a valid defense, and thereby ensure that people don't enter into Benami transaction. The other alternative suggested by Law Commission report was do not take such a harsh step. For all these years, people have been entering into Benami transaction. Therefore, let's have a piece of legislation which prevents the real owner from taking the property back from the Benamidar. All Benami transactions would therefore be regularized and Benamidars will become owners for all intents and purposes. But there is no criminality attached to the Benami transaction. Therefore, the Law Commission gave two suggestions. Either you make it an offense or you make provision as a civil provision and prevent the real owner from taking the property back. After giving both suggestions, Law Commission said we would rather give advice to the government to go by the second option of civil action rather than criminal action. This Law Commission report of 1973 was not acted upon for all 15 years. It's only in 1988 we had Benami Transaction Prohibition Act 1988. Now, there is a slight history I have only given on the screen, the provision of the Act. Initially, there was a Benami transaction prohibition ordinance. That ordinance was promulgated on 19th May 1988. There is a reason why I am mentioning the date. After the ordinance was promulgated, the issue was again referred back to the second time to the Law Commission, and we'll go to the 130th Law Commission's reports recommendation in a moment. After the recommendation of that second Law Commission report, that ordinance was made into an act. Now the act was enacted little later on 5th September 88. So from 19th May 88 to 5th September 88, ordinance held the field. From 5th September 88, the act replaced the ordinance. Now, why I'm spending so much of time on this? This has a very, very important bearing on the discussion that we have. Please have a look at section 1, subsection 3, which I have quoted over here. The provision of section 3, 5, and 8 shall come into force at once, and the remaining provision of this act shall be deemed to have come into force on 19th May 1988. This subsection was enacted to protect what has been done under the ordinance from 19th May 88 till the act is enacted on 5th September 88. But look at the problem, and this is the whole bone of contention and the whole rationale of the litigation, whole defense of the union, and the serious problem for the public. After 2016, Amendment Act was enacted, whereby the whole Benami Act underwent a change. Section 1, subsection 3 was not amended. And the argument of the union was that though amendments are made in the year 2016, and though the Amendment Act 2016 comes into force from 1st November or 25th October 2016, by virtue of the provision of subsection 3 of section 1, it will have retroactive impact, and the same will have to be read from 19th May 1988. I hope I'm clear about the problem. Problem was, when this section 1 subsection 3 was inserted, there were only 8 sections old act. In order to ensure that those section 1, 2, 4, 6, and 7, which were brought in by ordinance, are not hit for the period between 19th May 88 and 5th September 88, this provision was put in, and now the whole provision was being twisted by the government to claim that this provision makes it very clear that every provision, irrespective of when it was brought in, it will have to be treated as if it is in force right from 19th May 1988. We will, during the course of our discussion, examine the validity of this argument and how the court has viewed the issue, and how is it that the issue is answered is something which we will see. Now, let me go to very briefly the scheme of 1988 Act. As you can see, definition of Benami is a very short one. Benami transaction means any transaction in which property is transferred to one person for a consideration paid or provided by another person. Please recall what I had said a little while earlier. Tripartite versus bipartite Benami transactions. This definition covers only tripartite transaction. The bipartite transaction is not being covered. Please also see the traditional meaning of the term Benami, that I transfer property to someone else, but I continue to have beneficial ownership. I continue to be real owner. The other person is ostensible owner. And therefore, retention of beneficial ownership, or the fact that beneficial ownership is sitting in someone else and not the ostensible owner, which is a sine qua non or condition precedent for treating a transaction as Benami, is not reflected in this definition. All this becomes material as we will see along, but this is one factor that needs to be considered. So section 2 clause A, a very brief and completely, I won't use the word incoherent, but completely lopsided and half-baked definition of the term Benami transaction. Section 3, subsection 3.1 says nobody will enter into Benami transaction. And 3.3 said if you enter into Benami transaction, you will be punishable with imprisonment for a term which may extend to 3 years, or with fine, or both. Now please see over here. There is nothing like without a reasonable cause. There is no element of mens rea. So here, there is an element of offense without there being a need to prove mens rea on the part of prosecution. Again, please park this issue. We will come to this issue as and when we go a little further down in the discussion. Section 4 created a prohibition against the real owner from recovering the property back from the Benamidar. Section 5 expressly said that Benami property is liable to be acquired by the authority under subsection 2 without any amount to be paid. Now, section 5 therefore entitles the state to take over your property. By which process, in which manner, under what circumstances, that is not prescribed under section 5. Section 8 thereby permitted the government, union, or the state to make rules in this regard. Section 8(1)(b), the manner in which and procedure to be followed for the acquisition of properties under section 5, rules the central government was authorized to frame. So the legislature says government has a power, but under what circumstances the power will be exercised and by which procedure, that will be decided by the delegated legislation, by the government, by rules. We'll come back to this little later. Now, as I said, ordinance was referred to the Law Commission. And by that time, the Law Commission expressly stated that the way in which the ordinance in a way treated the transactions was not something which was very happy. It was suggested to cover every transaction. It also said that this act must operate retroactively. So all those who have entered into this transaction, which are Benami transaction, even prior to 1988, should now get covered by the new definition or by the new Act of 88, so as to result into a situation that people might be prosecuted, which may or may not happen under Article 20, but their properties are liable to be taken away. Fortunately, Supreme Court, while dealing with 1988 Act, has already taken a view that all transactions which are closed and concluded prior to 88 Act being enacted would not be hit. And therefore, this suggestion of the Law Commission did not really get acceptance from a court of law. Now, sections 3, 5 operated for the period from 1988 to 2006. But then whether the sections really operated or not. When called upon, the Government Council expressly stated that Section 5, which authorized government to take over the property, acquire the property without any consideration, has not been operationalized at all because the rules which were required to be framed for the purpose of implementing Section 5 have not been put into place at all. Therefore, though Section 5 was on the statute book, it was almost a dead letter because at no point of time government ever made use of it for want of any rules. There was some litigation under Section 4, real owner trying to get the property back, ostensible owner, Benamidar, saying you cannot take the property back, and Section 4 was held to be valid. Section 4 was therefore tested and upheld, but Section 5 was never in fact resorted to. Section 3, though the transaction was a Benami transaction, what was prohibited, even Section 3 in a way was not operationalized because there were no prosecutions under Section 3 as well. Now, probably government felt constrained by not being able to implement the law, and therefore this amendment is brought in. However, before we start looking into the amendments, if you look at the 1988 Act, the Act in a way was conspicuous by its non-operation. The Act covered only tripartite transaction and not bipartite transaction. The Act did not have mens rea as a defense, and the concept of beneficial interest in the property by the real owner as opposed to the ostensible owner, which is condition precedent for holding the property as Benami, they were all missing. The government therefore now amends the Benami Act in the year 2016. We'll examine only 3 amendments because they are the 3 amendments which are really important for our purpose. The first, you will find from the screen that there is an expansion of the definition of Benami transaction. Whereas we had old clause A dealing with tripartite transaction only, now if you look at section 2(9) clause A, where a property is transferred to or is held by, so tripartite and bipartite, both transactions are covered, and the concept of real owner having beneficial interest is also now captured by virtue of clause B, that property is held by the Benamidar for the immediate or future benefit, direct or indirect, to the person who has paid for the consideration. So in a way, the truncated old definition is being replaced by far more new exhaustive definition. That apart, 3 more situations are being covered now under clauses B, C, and D. Clause B says an arrangement or a transaction of a property carried out in a fictitious name is now Benami, where the transaction is carried out, but the owner of the property is not aware of or denies knowledge of the ownership, that's Benami, or a transactional arrangement in respect of a property where a person providing consideration is not traceable or is fictitious, that is also Benami. Therefore, now not only the definition of Benami is expanded, old clause A and now new capital A, but also there are new 3 clauses which are being inserted. Section 3, there was a criminal offense earlier. Now also under News Act, there is a criminality attached under Section 3. And Section 5, under which property was liable to be acquired by the government earlier, now it is liable to be confiscated under the amended section. Now, acquisition or confiscation in law would not really matter, and therefore there is not much of a qualitative difference by change of phraseology. I am also giving you a bird's eye view of what are other significant amendments in the scheme of the Act, and I am doing it for a reason. Please see, now the new amended Act runs into 72 sections. We have now Chapter 3, authorities under the Act, but we are concerned with Chapter 4, attachment, adjudication, and confiscation. Now, under the amended Act, there is a whole procedure prescribed in the Act itself. There is an initiating officer who will initiate the action. He might provisionally attach. He might then refer the matter to adjudicating officer. And then adjudicating officer will then ultimately adjudicate. We'll go to that a little later. Eventually, the property is liable to be confiscated, subject to right of appeal. But there is a whole chapter now under the Act. So what was left for the rule-making authority under Section 5, read with Section 8(1)(b) of the unamended Act, is now part of the parent Act. Similarly, old provision Section 3 only said it's an offense. Now, what is an offense is defined. Chapter 7, special courts are set up, and mens rea is expressly regarded as a defense available in relation to offense under the Act. Therefore, there is a significant qualitative change brought about by the Amendment Act. Now, let's see the controversy and how the court has examined it. The matter in the Supreme Court came from a judgment of the Calcutta High Court. So what were the facts in Calcutta High Court? Very briefly. In that case, petitioner purchased a property on 2nd May 2011. Please mark, after 1988, but before 2016. Now, the shares of the petitioner company were acquired by some other companies. The acquisition of the property by the petitioner company was regarded by the authority as acquisition of a Benami property. The authority took recourse of the amended definition under Section 2, Clause 9 of the amended Act, and took a position that this transaction is liable to be therefore confiscated under the amended provision. Notice was issued. There was a provisional attachment. The petitioner challenged that before the learned single judge. Learned single judge dismissed the petition, saying that you fight out with the department, don't come at this stage. The Petitioner carried the matter to High Court Division Bench. The Division Bench was called upon to decide whether invocation of the amended act provision to cover transaction which was closed and concluded before the amended act came into force is permissible or not. The argument of this union was that amended act is retrospective in nature. And why did they raise that argument? Please recall what I had said a little while earlier. Section 1, subsection 3 of the Benami Act, which was then introduced for the purpose of saving transaction between May 88 and September 88, is now sought to be utilized for the purpose of arguing that every section would come into force way back from May 88, and therefore transaction entered into by the petitioner after May 1988 would be hit by virtue of the amended provision, which by virtue of section 1 subsection 3 is deemed to have come into effect from 19th May 1988. The Calcutta High Court, in my view rightly, took up a position that Amendment Act of 2016 substitutes and widens the definition of Benami property and Benami transaction. We have seen that, therefore I am not going there. It also says absence of any express provision for retrospective operation of the Amendment Act of 2016, the transaction will be, the act would be regarded as applicable only from 1st November 16. Please see the Amendment Act very expressly states it comes into effect from 1st November 16. The union wanted to argue that under section 1(3) it relates back. They said no, this will come into effect from 20th November 16, and they relied upon the locus classicus judgment of Supreme Court in the case of Vatika, that surcharge in block assessment cannot be applied for the period prior to amendment of act, and said this will not be read retrospectively. Calcutta High Court also invoked Article 20 sub-article 1. We will go to that in much greater detail little while hereafter. Court also notes sections 3, 5 and 8 were never operationalized. They were dead letter on the statute book. And therefore, transactions carried out between the period May 88 and November 16 are deemed to have been accepted by the central government as vesting rights between the parties. And ultimately, it says, if you are now permitting state to effect this particular amendment to take its effect from a back date, this is a classic case of doctrine of colorable legislation, ulterior motive. It therefore struck down the action, quashed the proceedings. Union carried the matter to Supreme Court. And what were the arguments of the union? Arguments were, one, this is a procedural law, not a substantive law, and therefore can be applied retrospectively. That Amendment Act merely aids the Pre-Amendment Act by laying down attachment and confiscation mechanism with respect to Benami property. We have seen both these issues, so I am not going into it. The third, and that's very, very third and fourth, they're interrelated, that's very important. Confiscation and acquisition are of civil in nature. And if they are of a civil in nature, they are not punishment. And if they are not punishment, then adjudication is not of a prosecution. Article 20, sub-article 1, we'll see that in little greater detail, prohibits a penal action to be undertaken for an action or an act prior to the law being enacted. You can't be called upon, you can't be adjudged as an offender for an offense, which when act was committed was not an offense. You can't have a retrospective definition of an offense so as to make a transaction entered into legally, illegally. But that is all in the matter of offense. That's all in the matter of a criminal action. The argument was confiscation or acquisition is not in the nature of a criminal action. It's a civil action, and therefore there is no need to hold that the provision is not retroactive. Article 20, subarticle 1, therefore would not prohibit this transaction. Article 14, all of us are aware, gives equality before law and equal protection of law. Article 19(1)(g) is a fundamental right given to every person to carry on any profession, occupation, trade, or business. The case of the petitioner was that these provisions are violative of Article 14 and 19(1)(g). Now comes the twist. If you have recalled what we discussed till now, you would find at no point of time anyone had tested the legality of old Section 3 or old Section 5. Old Section 3 or old Section 5. Why they were not tested? They were not operationalized. Before Calcutta High Court also, Section 3 or Section 5 were not subject matter of challenge, old. Calcutta High Court rested its judgment on the short ground that you cannot give effect to this provision retrospectively, and what was permissible at the time when the act took place in the year 2011 cannot now be held to be impermissible by virtue of definition of Benami transaction brought in on the statute book in the year 2016. The approach of the Calcutta High Court was therefore, in a way, straightforward and the narrow one. The Supreme Court takes up far greater or larger challenge. Supreme Court starts examining but whether Section 3, old Section 3 is valid, whether old Section 5 is valid. Why is Supreme Court examining this? Because if old Section 3 is invalid, because if old Section 5 is invalid, where is the question of retrospectivity? Because if it is invalid, it is non-est. And if it is non-est, you can't attach this transaction to an earlier period and regularize it, because what was in earlier period was not there at all. It's an illegal transaction. It's an illegal piece of legislation. Look at the interesting way the Supreme Court deals with this situation. Supreme Court says, let's first test whether old Section 3, unamended Section 3 and unamended Section 5 are valid or not. The court says, merely because this legislation was not challenged for all these years is irrelevant. Today, when the matter comes before us, we need to examine. Power is vested in Constitutional Court to look into the validity of a piece of legislation, irrespective of the fact whether anyone had challenged at any point of time in past. We can examine both procedurally and substantively. And we will examine it from the perspective of Articles 14, 19, and 21. It should be 20, subarticle 1. Then the Supreme Court says, for 4 reasons, old Section 3 is invalid. Now, the moment we see the reason, you will recall why I was emphasizing some of the issues. 1, old Section 3 did not have the concept of mens rea in the matter of criminal trial. Any provision in which any so-called criminal act where there is no concept of mens rea would be fundamentally erroneous. Now, it's possible. You can legislatively provide that burden of proof may shift from the prosecution to the accused, but there has to be a concept of mens rea. Supreme Court says old Section 3 did not have this concept. Second, the concept of beneficial ownership vis-a-vis real ownership, a condition precedent for the purpose of holding Benami transaction, was missing. Section merely said A transferring property to B for the benefit of C. But that B is holding property for the benefit of C, that concept of Benami for the beneficial aspect was missing. This is the second reason. Third, for all these 28 years, you have never operationalized this provision. So significant time interval leading to non-utilization of criminal provision would make it invalid. And fourth, the sections, if you read together, they are liable to be struck down on the ground of manifest arbitrariness. I am not getting into the concept of manifest arbitrariness. For quite some time, the courts only took a view that a piece of legislation can be struck down if it is violative of fundamental right or if it is beyond the legislative competence. However, during last 10 years, 8 years, Supreme Court has invoked the third head of striking down a piece of legislation, namely it's manifestly arbitrary. If it shocks the conscience of the court and if it is found that the provision is ex facie bad, that is also a ground for striking down. So on these four grounds, Supreme Court says old Section 3 must go. Supreme Court then turns to old Section 5. Supreme Court says old Section 5, there are no rules. There were no procedural safeguards. They were left to be laid down by the delegated legislation. Now, they were never laid down. If they were never laid down, the fact that now under the provision of the Act, there is Chapter 4, which lays down the procedure for adjudication and confiscation, would not mean that we will read this provision for the earlier period. These gaps are essential, substantive in nature, and therefore the provision was inconclusive. The provision was, if I use the language of the Supreme Court took a view that this provision was too half-baked provision. It was a fanciful provision. It was an oppressive provision. It was an overboard provision. Extremely strong language used by the Supreme Court. Court says for these reasons, even Section 5 is bad. Then the Supreme Court was concerned with the next situation. And this is where the whole problem lies. Government said, fine, hold that Section 3 is bad, hold Section 5 is bad, old Section 3, old Section 5. But then the confiscation is a civil action. If it's a civil action, law can always provide retrospectivity in relation to a civil action. And therefore, if by virtue of the amended provision, we are now trying to take action to confiscate property, under which law the people will be able to defend that action. Because if it is Benami under Section 2, Clause 9 under the new Act, it is liable to be confiscated. Section 2, Clause 9 does not say that transaction entered into after a particular date. So today, the argument ran, today, if it is found that in the year 2011, a property was acquired in breach of the definition of a Benami transaction, under section 2, clause 9, it's a Benami transaction. If it's a Benami transaction, we can take action today also. Therefore, the argument was this is a retroactive provision and we should be entitled to take over the property. Now, here comes the brilliance of, I'm using the word brilliance for good reason. Brilliance of the judges in dealing with this issue. Now, please recall the limited ground on which Calcutta High Court had rested its judgment, that you can't invoke definition of Benami in relation to transactions which were entered into before the definition came into force. That was, as I said, a surer and a shorter path. But the Supreme Court takes up far more complex and far more, in a way, challenged path. Not that that shorter path is not examined, I'll go to that little later. Supreme Court says, let's now examine the issue from Article 20, Sub-Article 1. Article 20, Sub-Article 1 provides, no person shall be convicted of an offence except for the violation of law in force at the time of commission of the act, charges an offence, nor, we are concerned with the second part, shall be subjected to a penalty greater than that which may have been inflicted under the law in force at the time of commission of the offence. Therefore, if confiscation is penal in nature, then a retrospective amendment cannot protect it. But if confiscation is civil in nature, then there could always be a retrospective legislation. The court therefore starts examining the issue whether confiscation is punitive or not. We'll go to the finding. So let me stop over here. Let me now, on first principle, discuss. The Supreme Court starts examining the matter from this perspective. What is confiscation? Court says there are two different kinds of confiscations. One, confiscations which result from civil action. And second, confiscation, which is the result of adjudication of a criminal proceedings. The law laid down is that where confiscation follows a criminal adjudication, a person is tried in a criminal court, found to be guilty, and as a result of the guilt found, his property is confiscated, then it is in the nature of civil confiscation because it is dependent upon a finding of a court. But where confiscation is independent of the proof of an offense, the confiscation is in the nature of penalty because authority decides whether the person's property is liable to be confiscated or not. Please see very, very subtle but important distinction. If property is taken over by government post or in order to give effect to or as a consequence of a criminal trial, it is a criminal action. It's a civil confiscation and can always take place. retroactively. But if the authority decides that no, you are guilty, in the present case, the adjudicating authority will decide you have committed breach of the provision of the Benami Act. Your transaction is a Benami transaction. I therefore decide to hold you guilty. He can't try, because trial of an offense is by the special court. So I'm not saying he will try, but having held that this is a Benami transaction and a Benami property, he would then take a view, I will now hold that property must be confiscated by the government. The court takes a view, such a confiscation is in the nature of penalty. And if such a confiscation is in nature of penalty, then you cannot implement such penal provision from a retroactive date. So a transaction when it was entered into was valid. You cannot, the authority cannot say that we believe that it is illegal and cannot then confiscate. As a result, the court took a view, okay, one, section 3 of the old act is invalid. 2, section 5 of the old act is invalid. 3, 2016 amendment is not procedural, it's a substantive provision. 4, section 5 2016 act of confiscation is punitive in nature and therefore can be applied only prospectively and not retrospectively. 5, therefore, concerned authorities cannot initiate or continue criminal prosecution or confiscation proceeding for transactions entered into prior to coming into force of 2016 Act, 25th October 2016. As a consequence of the above declaration, all such prosecutions or confiscation proceeding shall stand quashed. Across the board, every proceeding is quashed. Court also says, even this new provision is valid or not, we are not examining because it is not being argued before us. So what is the sequitur? Okay, before I go to sequitur, court also notes the argument which appealed to Calcutta High Court, which I said is a shortcut argument, that you cannot hold a person guilty of committing an offense by virtue of the expanded definition of the term Benami transaction, whereby clause A is significantly expanded and clauses B, C, and D are inserted. You cannot use them for transactions entered into prior to that definition, because what was permissible earlier cannot be made impermissible. So that part of Calcutta High Court judgment is also confirmed. I'm not saying that is not addressed, but instead of addressing the issue from a limited angle, Supreme Court has addressed the issue from far more exhaustive angle. Now somebody can say that if confiscation pursuant to criminal trial is a civil consequence and therefore can be applied retroactively, what prevents authority to bring confiscation proceeding post a criminal trial under the old act? That cannot happen because old section 3 is held to be invalid. So no prosecution under old section 3 can at all be initiated. Prosecution, if at all, will be only under the new section, and that is the reason why every action, prosecutions and confiscation in relation to actions prior to 25th October 2016 stand quashed. Finally, what is the fallout? We have seen the legal effect of the confiscation generally. All concluded transactions will automatically go out, what would happen to the concluded transactions which are partly concluded? Let's say in the year 2012, let's say in Gujarat and in Maharashtra, a non-agriculturist cannot buy an agricultural land. So I want to buy an agricultural land. I am not an agriculturist. So I catch hold of an agriculturist. I say, I give you rupees 50 lakh. You buy an agricultural land, but it is for me. We'll then get it converted to non-agricultural land. And then when the land becomes non-agricultural land, you transfer it to me for, I already paid rupees 50 lakh, therefore you don't have to take any amount from me. First part of the transaction is already over. I have paid him rupees 50 lakh. He has purchased the land. He is now holding the land. That transaction, though it is Benami, it is now immunized because transactions prior to 2016 are now completely immunized. But land is as yet not non-agricultural land. So it is not transferred to me. Let us say it becomes non-agricultural land today. What is the consequence? The consequence is Section 4, Old Act, which is not touched by amendment, which is held as valid. I cannot ask for land being transferred to me. If I file a suit for specific performance, it may be hit. I may not be able to get back rupees 50 lakh on the principle of pari delicto. But land would not go away. It cannot be confiscated by government under any circumstances. Whether an amended act is valid or not, for want of time, I'm not getting into it. But probably Supreme Court has kept that issue open and therefore someday it will be examined. Finally, what about PMLA and the confiscations under PMLA? In this very judgment, Supreme Court puts a question mark about correctness of PMLA judgment. As we are all aware, that is now being taken in review. But then there is one fundamental distinction of confiscation under the Benami Act and PMLA. Under PMLA, confiscation is only post the proof of conviction in a criminal case. So it is possible to argue for the union, even by under this judgment, that it is of a civil nature. In any case, under PMLA, the question of retrospectivity is not being raised, but maybe in a given case, that argument would be raised.
Benami asset purchased earlier, but still held as on today. And the transaction concluded earlier, but it also applies to transactions which are present. Can those transactions be covered by the Supreme Court judgment? Because not retrospective.
No. Please take an example.
So, Benami transaction, A party purchased property on behalf of B party, consideration paid by B party.
Correct.
In the name of A. This happened in 2011.
Correct.
But transaction at property.
A is thereafter not transferred the property to B.
Yes. That Benami property remains as it is today, even today.
It will remain as in the hands of A. B will not be able to file suit for specific performance because Section 4 will prevent him from doing that. But yes, suppose A were to transfer it. There is no prohibition in law against A from transferring it. But B cannot compel him to transfer.
Okay. So because the old definition of Benami law was purchase of property, consideration by another. Now the definition is property is transferred to or is held by.
Correct. Old was only tripartite. This is tripartite or bipartite.
Bipartite.
See, held by means I transfer the property to you without having any desire to make you the real owner. Then you are holding it, but you are not holding it for yourself. So held by is added to make bipartite transaction a Benami transaction. And that is what Supreme Court says. For want of time, I'm not going into far more greater detail. Supreme Court judgment is a very beautiful discussion on this. The tripartite and bipartite both were covered. Otherwise, with the classical definition of Benami, the unamended act only covered tripartite. It's only by the amended act bipartite is covered.
No, but the point is that though the transaction happened earlier,
so it was a tripartite transaction, it was a Benami transaction.
Okay, and now
because it is not as if I have transferred property to you. Let's say Parag Bhai transferred property to you with my money. He is not concerned. He is just asking. I'm asking him execute sale deed in the name of Dharan Gandhi. So, arrangement is between two of us. He is the vendor. So it is a Benami transaction.
Okay.
It's a Benami transaction by virtue of the fact that Section 3, old Section 3 is struck down. There will be no now criminality.
Correct.
Section 4 is upheld.
Because the transaction happened in 2011.
Correct. And Section 4 is on the statute book from 1988.
Okay.
And that is not disturbed by the Supreme Court.
Correct.
So which would mean that I would have no right to insist for transfer of property back to me. But if you want to transfer, there is no prohibition.
No prohibition. Yes. Sir, second question, by virtue of Supreme Court judgment, all the cases where either the initiating officer has initiated the proceedings or it is pending before the adjudicating authority or it is pending before the tribunal, cases where they are targeting transactions prior to 2016.
Correct.
Automatically, each and every confiscation goes, attachment goes.
In a way it goes, but then there has to be an order to that effect. Otherwise, there will always be some cloud over the title. So it is obviously very necessary that you get that cloud clear. For example, before Gujarat High Court, large number of petitions are filed challenging all these actions. Where I appear, we have got the matters posted before a hearing on Monday.
Okay.
So that we can get every proceeding cost. So wherever the proceedings are lying, you must get a formal order of dropping of the proceedings. Otherwise, someday somebody can come up with that order of attachment or confiscation. And unlike Ashish Agrawal, where Supreme Court has invoked Article 142.
Yes.
This is not under 142.
Yes.
So you'll need a specific order.
And in case where the proceedings are not live, I have failed to exercise my remedy as it stands today. But today, if I file an application before the IO or adjudicating authority,
he is bound to accept it. If he doesn't do it, then you have to go to High Court and get it cost.
So transactions happening after 2016, those can attract criminal liability.
They can. Yes.
They can attract criminal liability. And
though, one second, I am not very sure why Supreme Court has said
Section 3.2, yes.
3.2 of the amended act is also invalid. I don't know why that particular observation is made. Just see that particular observation.
With 95 para 80, but yes.
I have quoted that. Just see.
Do they mean to the extent of old, because they quote Article 20 clause 1?
So probably where the new section of it, where the prosecution is initiated under new section,
but for
in relation to an old offense, it will get cost. Otherwise, Supreme Court had no occasion to deal with the amended provision, and in fact, that issue is kept open.
Kept open. And sir, the conclusion para also, where they said 2016 is unconstitutional.
That issue is kept open.
They say it is violative. Section 3.2 of the 2016 Act is also unconstitutional as it is violative of Article 21 of the Constitution. So this is probably referring to the prosecutions after 16 relating to transactions prior to 16.
You are referring to the final conclusion?
Yes, final conclusion, para A.
So this is the para A.
3.2 of 2016 is also unconstitutional as it is violative of Article 21 of the Constitution.
Now, I don't know why 3.2, because 3.2 is in fact an exception to 3.1. Probably what they mean is 3.3.
Correct.
3.1 defines what is, you shall not enter into Benami transaction. 3.2 says, but these are not the Benami transaction. And 3.3 says, there will be offense. So probably when 3.2 appears to be a typing error.
Okay.
Just see 3.3, old 3.2. old 3.2 makes an exception.
Yes, it makes the exception.
So probably that is not what was meant. What they meant was 3.1. No, 3.3, not
3.3. Old 3.3, which is now renumbered as 3.2.
Huh.
And lastly, sir, will this have any bearing on Black Money Act to argue that you cannot tax the assets which were acquired prior to 15?
See, same larger issue. If it is civil confiscation, they have a right to do it. If it's criminal in nature, they would not have a right to do it. Probably under Black Money Act, it is the authority which adjudicates and not the criminal. I'm not very sure. I have not seen the
authority, income tax authority, sir.
Then probably you are right to say that then it will be confiscatory in nature and therefore retrospective.
Okay.
But I'm not expressing final call. It's possible to argue.
So there is one question in the question answer.
Hmm.
Gandhi, he is clarifying my question. Mr. Gandhi's question was whether Benami proceedings for a property purchased in 2011 can still be initiated today. In other words, is it a continuing offense?
No. This is not a continuing offense. Purchase is complete once it is complete. Continued ownership is not an offense. What is offense is the purchase, not the ownership.
Okay. Because sir, under Black Money Act, I think we have this problem that though a transaction of purchase of a foreign asset has taken place prior to 15, but if it is still held after 15, there is a possibility to say you are the owner of undisclosed foreign asset and therefore the new law will apply.
Yes, but that's a different ball game. So we will have to separately examine.
Yes, I understood your point that here the offense is purchase, not the ownership.
No, not the continued ownership.